Right now, one of the biggest obstacles that we're seeing in our world is organizing for folks to do the double move. And oftentimes that means creating some creative options. So occupancy agreements, hold harmless agreements, storage agreements, trying to organize a workable solution for all parties when we're trying to organize that double close.
So, all right. So I like how you said a storage agreement. Let's chop these all up quickly for our listeners. So storage agreement, it might be something that people are not thinking about. Can you explain that?
So, I mean, it really can be a number of different ways that it can be organized where the seller perhaps can't leave and they move all of their belongings into their garage and say to the buyer, is it okay if we store our belongings here for a couple of days or a week? Sometimes compensation is arranged, sometimes not. So, there's lots of different ways that it can be organized, and a hold harmless is typically put in place, which basically is an indemnification stating that there will not be any liability for the buyer, the new homeowner, if something were to happen, God forbid, to the seller's belongings in that garage. In some cases, it's the other way around, where the buyers need to move their belongings in advance of the closing.
Sure.
So then again, we may be structuring something where the sellers say, okay, well, we'll let you use the basement, so you can put your things in there, and now you've got a quote-unquote true storage situation. Otherwise, we've actually had situations where people will allow for occupancy in advance. That one always makes me a little bit nervous because I've been bit on this before.
Oh, really?
Yes, I had a seller
do tell.
Years ago, my first year of practice, the seller allowed the buyers to move in. Long story short, the buyers ended up losing their financing and were unable to close on the house. So themselves and all of their possessions were there in a strewn about, unorganized kind of way, and now my client had to go about evicting them because they didn't put any documentation and paperwork in place. One of the other things that can be done in those types of short-term occupancy agreements or use and storage agreements is to identify what kind of relationship we're creating. From a legal perspective, we're not creating a landlord-tenant situation. Oftentimes there is no compensation, so it's really akin more to a license. And in that case, we want to define it as a license relationship so that we, as whomever may have to do the eventual removal, is not going to be relegated to the landlord-tenant handbook. I'm seeing this again with some degree of regularity where sellers are wanting to hold over because they're not ready to move out. Their next closing isn't ready. Their new construction house isn't ready. So now what kind of situation does that create for a buyer? I just had this happen. There was not an opportunity for a meaningful walkthrough. Right? The walkthrough is probably one of the most important exercises that a buyer does, where now they're taking the property as is. So to be able to determine that that property is exact, in this case, they were unable to do so. There was damage to the hardwood floors underneath one of the beds. You would not have been able to identify the damage under the bed because it's under the bed. If the walkthrough had been done when the house was vacant, we would have seen it.
Yeah.
So you definitely need to have, in that case, maybe a security deposit in place and some sort of expectation that there will be a walkthrough after the seller vacates so that the buyers are not diminished of that right to complete a walkthrough pursuant to the purchase and sales to examine and make sure that all the removal happened the way it should have.